Welcome to the Law Study Journal. Notes from the Law Desk. Law simplified through a student's lens, with the help of AI. Starting it with Title 1 of the Revised Penal Code, Articles 3 to 15. Article 3. What is a felony? Article 3 defines felonies as acts and omissions punishable by law. So you can commit a felony by doing something prohibited or failing to do something required if you have a legal duty to act. Then it explains two ways felonies are committed. 1. Deceit, dolo, deliberate intent. 2. Fault, culpa, no intent to cause the wrong, but it happens due to imprudence, negligence, lack of foresight, or lack of skill. In simple words, dolo. I meant to do it. Culpa. I didn't mean it, but I was careless. Article 4. When does criminal liability attach? Article 4 gives two key rules. First rule: if you commit a felony, you can be liable even if the harmful result is different from what you intended. Meaning, the law looks at what you did and the results that naturally followed, even if you say, "That's not what I planned." Second rule: liability can arise even in an impossible crime. When someone performs an act that would be a crime against persons or property, but it can't be completed because it's inherently impossible or the means are ineffective. The focus is the dangerous act and intent, not a successful outcome. Article 5. What if the act is wrong but not punishable? What if penalty is excessive? Article 5 acknowledges a real-world problem. Sometimes an act seems harmful, but no law punishes it. Courts can't invent crimes, so they decide the case based on existing law, then report to the chief executive through DOJ, suggesting a new penal law. It also says, if applying the code results in a clearly excessive penalty, considering malice and injury, the court may report that too, but the sentence still proceeds. Article 6. Stages. Attempted, frustrated, consummated. Article 6 is the exam favorite. Consummated. All elements are present. The crime is completed. Frustrated. The offender performs all acts of execution that should produce the crime, but it doesn't happen due to causes independent of the offender's will. Attempted. The offender begins committing the felony directly by overt acts, but doesn't perform all acts of execution because of some cause or accident, not because they voluntarily stopped. The key phrase is overt acts. The law punishes actions that clearly move toward committing the crime, not mere thoughts. Article 7. When are light felonies punishable? Light felonies are punishable only when consummated, meaning completed. Exception: light felonies against persons or property can be punishable even if not consummated, depending on the situation. Takeaway: the law treats minor offenses differently, but it becomes stricter when harm targets persons or property. Article 8. Conspiracy and proposal. Definitions. Conspiracy: two or more agree to commit a felony and decide to do it. Proposal: someone decided to commit a felony and proposes it to others. Big rule: conspiracy and proposal are punishable only in cases where the law specifically provides a penalty, so it's not automatically a crime to conspire, unless a specific law says it is. Article 9. Grave, less grave, light felonies. This article classifies felonies based on penalties. Grave: punished by the most severe penalties, as defined in the Code's penalty framework. Less grave: punished by correctional penalties at maximum. Light: punished by arresto menor, or fine within the stated limit, or both. Why this matters? Classification affects things like punishability of attempts and how the law treats certain situations. Article 10, Special Laws versus the RPC. Article 10 says offenses punishable under special laws are not subject to the RPC's provisions by default. but the RPC can be supplementary unless the special law says otherwise. Practical meaning. You always check if a case falls under the RPC or a special law, because the rules may differ. Article 11. Justifying circumstances. Justifying circumstances mean the law says the act is not criminal under the situation. The most famous is self-defense, and it requires unlawful aggression. There must be an actual attack or threat, reasonable necessity of the means used to prevent or repel it, and lack of sufficient provocation by the defender. There are also defense of relatives, defense of strangers, must not be motivated by revenge, state of necessity, avoid a greater evil with no less harmful means, fulfillment of duty and obedience to a lawful order. Article 12. Exempting circumstances. Exempting circumstances acknowledge something wrong happened, but the law excuses the actor due to condition or situation. Examples include insanity/imbecility, with rules on confinement, minority as stated in the codal, accident while doing a lawful act with due care, without fault or intent, irresistible force, uncontrollable fear, insuperable cause preventing a required act. Quick memory recall. Justifying. Act is lawful. Exempting. Actor is excused. Article 13. Mitigating circumstances. These reduce penalty, like incomplete justifying, exempting requisites, no intent to commit so grave a wrong, sufficient provocation, voluntary surrender or confession, illness diminishing willpower, and analogous circumstances. Article 14. Aggravating circumstances. These increase penalty, like taking advantage of public position, abuse of confidence, nighttime to uninhabited place, banned when it facilitates the crime, calamities, recidivism, evident premeditation, fraud, disguise, superior strength, treachery, unlawful entry, breaking, using motor vehicles, and deliberately increasing unnecessary harm. Quick memory recall. Mitigating circumstances. Reduce penalty. Aggravating circumstances. Increase penalty. Article 15. Alternative circumstances. Alternative circumstances can mitigate or aggravate. These depend on the case. Relationship, intoxication, mitigating if not habitual and not intentional, aggravating if habitual or intentional, instruction, education level. Personal study notes and reflections, for educational discussion only, not legal advice.